Reddy. We are here live from Houston, Texas. Every Tuesday at 5 p.m. Central Time, Reddy Neumann BC does bring in immigration updates. Along with me is my business partner, Emily Neumann. Emily, this bipartisan bill that is proposing to have 40,000 green cards, can you explain more about it? I mean, what are the possibilities of success? Who are included in it?
Right, so we're looking at basically recapturing unused green cards, 40,000 of them, and setting aside 25,000 of those for nurses and 15,000 for doctors. And these green cards are going to be distributed based on priority date, not based on the 7% cap or country of birth.
So the country of birth is not included in it. It's
Correct.
Everybody gets equal treatment.
Correct.
So is it limited only to, how about physical therapists, occupational therapists?
At this point, it's only nurses and doctors. Of course, this is just a proposed bill, so possibly we could see amendments that might.
Does it require that these nurses should be working with the COVID patients? Or is it just the healthcare worker?
I think it's just any healthcare worker, but.
Okay. And what are the possibilities, do you think, that this is going to be passed in the...
I would say out of any immigration bill that's been proposed in recent years, this probably has the best chance of actually passing. There's a lot of people that would be on board with it. I think, we're, especially in a pandemic, realizing how important having nurses and doctors are and realizing how much of a shortage we actually have, especially in rural areas. So I do think it has a good chance of actually making it through. And it's not actually adding new green cards, it's just recapturing ones that went wasted.
There's a lot of rumors flying that there is some executive action or some action is about to happen on the OPT and STEM extension. Things were being published in the Forbes news article. And what do you expect the Trump administration to do on the OPT or STEM extension?
So I think that the OPT and the STEM extension are both regulatory, meaning that when they were created, or at least the provisions that we have to abide by right now are all set in regulation. And the only way to change those is to go through a new regulatory process. So I don't think the president has the power to unilaterally block OPT or STEM extensions through an executive order. And what people need to realize is we already know they're planning on making changes to the OPT and STEM OPT regulations. That came out in the regulatory agenda last fall, that they were planning on making these modifications and that we were expecting to see a proposed regulation in August of this year. So this is not new news. What's new is the Trump administration trying to gain support for making it more restrictive by using this pandemic, by using the fact that this virus, originated in China and saying Chinese students have some sort of involvement in it. So I think that there's not much he can do immediately with immediate effect through executive order. I do expect we'll see proposed regulations, and remember, that means it has to go through the regulatory process. We can submit comments. There are a lot of people that are for OPT and STEM extension. So it doesn't mean we'll ever get a final regulation.
To just explain you how the legal system works in the common law countries and also in United States mostly, is that the Constitution is on the top of the list. I mean, that is the top law that cannot be violated. Then comes the legislation passed by the Parliament. Here in USA, we call that as Congress. So that comes under the highest priority after the Constitution is the law that's passed by the Congress. Then comes the regulations. Regulations are issued by the administration. That means Trump administration in this particular case, if there are any new regulations. However, there are strict guidelines with regards to what, how, and when how the regulations can be issued, and we have time to comment over it, and they have to answer those questions, why they are doing, why, and they have to give explanations to everything what we ask questions when they give time for us to ask questions. That's called regulations. Then comes the executive order. That means that the president just issues an order saying that, okay, this is what it's going to be done. So the executive order, what Emily was describing, what people are hearing is that It cannot violate the Constitution. It cannot violate the law passed by the Congress. It cannot contradict the regulations that they passed it. So if OPT and STEM extension were to be modified, they should take it to the regulatory method, which is going to take a long period of time. It's not going to be short-term achieved. It cannot be unilaterally done by the administration with a simple letter or simple document. It has to go through the regulatory process. So that might take a long time. Emily, on the immigration ban, on April 20th, we saw Trump tweeting in the middle of the night, oops, I'm going to ban the immigration. Then later on, we explained that, well, this banning of the immigration actually is helping the business immigration overall instead of harming. Can you explain how that works, Emily?
Right. So this ban impacts people applying for immigrant visas outside the U.S. at the consulate. The vast majority of people in that situation are in the family-based categories, as most employment-based immigrants receive their green card through the adjustment of status process in the United States, which is not impacted by this ban. So when we have fewer family-based green cards being issued and there's leftover at the end of the fiscal year, those actually are reintroduced next year in the employment-based category. So we have this spillover from unused family-based green cards that will go towards the employment-based green cards in October. So that could help us with some forward movement in the backlogged priority dates.
So if the things turn out, we will see positive results coming in October, but don't expect EB2 to move very fast, guys, because EB1 is also backlogged, so don't expect EB2 to move very forward. But I do expect, if things continue as it is, EB1 to definitely move from the current date, which is 2015 right now. It should be expected to move. Emily, on the backlog of the employment-based green cards have reached to 800,000 green cards right now. These are the people, mostly the I-140 has been approved and they are waiting. And most of them happens to be Indian nationals. Do you see any relief? And I see the questions coming up there. Hey, what about Senate 386 bill? What's going on that? Can you educate more on that?
Yeah, this bill, the Fairness for High-Skilled Immigrants, it did pass the House with a lot of support. It had a lot of steam going into the Senate, and then it all fizzled out when they tried to go the unanimous consent route. And then everyone's been preoccupied with the pandemic since then. I see very little chances for this going through. Now we're in an election year. I don't see a whole lot of laws being passed, especially not those that are, even though all it's doing is leveling the playing field, if it happens to be benefiting one group disproportionately compared to others, they're going to claim that you're just giving green cards to Indians. That's always the other side of the argument that people are trying to make. So when we're in a pandemic, when Americans are out of work, immigrants tend to be the first group that gets targeted. So I just don't feel there's a lot of likelihood of that passing this year.
Let's go to the questions and answers. And people are asking, is there any update on the Senate 386 bill? As we explained, no, there is no update on Senate 386 bill. There was also a question asked whether physical therapists and occupational therapists are included in the healthcare bill. At this point of time, they are only considering the nurses and the doctors. Now, there was at one point of time back in where they have given extra 50,000 green cards for nurses and physical therapists, though. That is not the same at this time. They're only including the unused green cards, the 40,000 green cards only for nurses and that of doctors, not physical therapists at this point of time.
Pulkit from Facebook has an I-140 approved for one position for a hospitalist and recently changed jobs to a nephrologist at the same hospital and wants to know if the first I-140 for the first job could be used for filing the green card under this new bill. I think it really depends on whether the position is similar enough in the job opening, the terms and conditions are the same, such that the I-140 remains valid with respect to the new job without really having more details. It's hard to say. it kind of, I would lean towards you might need a new I-140 for the new position in order to take advantage of actually filing the adjustment of status under this bill.
Rajneesh Kumar from Facebook has this question. He has he's moving from company A, he's moving from L1A, sorry, to H1B as a cap subject thing, and he's going to stay out of the country for 1 year and then go through the lottery system. Does the 6 years restart all over, or does the L1 period counts? If you stay outside the country for more than 1 year, and if you are applying H1B in the lottery, everything restarts. Everything restarts.
Resham from Facebook has a STEM OPT expiring soon and was not selected in this year's lottery. The employer is able to file a cap-exempt H-1B, wants to know what the processing time is and what happens if it does not get approved. So we are seeing processing times for H-1B petitions anywhere from, I would say, 2 months to 6 to 8 months because there's no premium processing right now. In the event of a denial, it really depends on when that happens. But remember, you're maintaining your F1 status through the end of your STEM OPT plus the 60-day grace period. So if a denial were to happen during that 60-day grace period, you continue your 60-day grace period until it expires, and so you have the opportunity to file a change of status to any other category. If it occurs after the 60-day grace period expires, that denial would put you out of status. There's not really a good option to remain in the U.S. once you've fallen out of status. Arthi from Facebook wants to know if we can file for the I-765 EAD while the person is not in the United States. No, you have to be physically present in the U.S. in order to file the I-765 application. Once it's filed, you could potentially travel while it's pending without causing a negative impact on it, but you have to be in the U.S. at the time of filing. Pritam wants to know when consulates are going to open. Obviously that's a great question. If we could look in our magic ball or magic mirror, we'd be able to maybe answer it. I will say that I've had a couple of clients that were able to schedule interviews in July at some of the consulates. We don't know whether that date will hold. There's these closures keep getting extended and extended just depending on what's going on with the virus in that particular location. So hopefully this summer we'll see those reopening. I think it 100% depends on what is going on with this virus. Whether we have things under control and whether that particular country has things under control.
Question on YouTube is that I have applied for the H1 to H4 change of status. My max out is on June of 2020. Since the H4 is not approved, can I continue staying in this country or should I go back? You can continue staying in this country. You don't have to go back. Since your H4 is pending, you are in legal status. You don't have to go back. Next question, Vivek is asking from YouTube. The H1B employer is having a 10% pay cut for 3 months period. Does he need to file an amendment? If it falls below the LCA wage, sure, you have to file an amendment, otherwise you'll be violating the status.
Rahul from Facebook has an H-1B extension pending with the same employer and wants to know what the options are for travel while that extension is pending. So if your current validity period has not yet expired and you filed your extension, you can go out and come back in as long as you're going to return before the current petition expires. If you're going to return after it expires, you have to wait for the approval, get the new visa stamp, and then come in. But if you do come back before it expires, be aware that it is going to create an issue with your I-94 number because your extension was filed with the old I-94 number, but now that you've re-entered, you've gotten a new I-94 number. Your extension approval is likely to come with the old number, creating a mismatch. So depending on the situation, you could try to have that rectified while the application is pending by having your employer send in your new I-94 number and asking USCIS to update it. Otherwise, the other way to correct it would be to travel again after your H-1B extension has been approved.
Questions from
Venkat from Facebook has an extension petition that got denied, and he cannot leave due to the COVID-19 situation. And yeah, definitely a tough situation to be in. I'm assuming your I-94 has already expired. The only option really you have is to file a late change of status to B2, requesting a nunc-pro-tunc extension or change of status with extension that puts you back in status, explaining that the denial was an extraordinary circumstance that was beyond your control and that you can't physically travel because the travel is restricted right now. That application can be filed online on the USCIS website. Be aware, though, that from the date of denial going forward, even though you filed this nunc-pro-tunc request, if it's not ultimately approved and you stay for more than 180 days, you could negatively impact your ability to come back because you might be subject to the unlawful presence bar. So yes, if you have the option of filing this nunc-pro-tunc request, but you should still keep an eye on that 180-day clock from the day of the denial, because that's the day unlawful presence begins, and you need to make sure that you either have the change of status to B2 approved or you exit before you hit 180 days.
Question from YouTube is that Vimal has that how does he know if his day one CPT college is a good college, and once his H-1B gets picked up, will he has any problem? Number one, all day one CPTs, according to us, are all illegal. They're operating illegally. There are only 9 or 10 institutions out of the 9,000 institutions that are giving day one CPTs. So please, don't go to day one CPTs. That's our request.
Kirat from Facebook wants to know if a student with F1 and OPT can apply for unemployment benefits if he's been laid off due to the COVID-19 situation. So in order to qualify for unemployment benefits when you have an EAD, it needs to be an unrestricted employment authorization. That means that if you have this type of EAD, you could go out anywhere tomorrow and get a new job with any company doing any kind of job. For OPT, that's not the case because you can only work for companies or for jobs that are in your particular field of study, and you have to be in compliance with the OPT requirements, that it has to be at least 20 hours per week and paid if you're on the STEM extension. So because the OPT, when it comes to F1 status, is restricted, that means you're not eligible for unemployment benefits.
Avinash has this question. He was having a DWI. The case was disposed in 2014, no jail time. Will he have any problem with the H-1B or GC processing, whether it's in United States or outside the country? When you go for, if you're changing the status from OPT to H-1B, we're not expecting much problem, but you need to inform the USCIS that you have been arrested for the DWI and give all the documents. In the H-1B also, when you go to the consulate though, they will ask you to have a medical test done. After you make an appointment, they will ask you to do the medical test done. And after medical and psychological test has been done, then only the consulate will adjudicate your H-1B visa. Also, when it comes to the green card, you have to inform at every stage with your immigration lawyer that this activity happened. So please inform your lawyer about this. And they have to tick a box. Have you ever been arrested? You are supposed to answer yes to that question. You're supposed to provide all the information that is required for the USCIS officer to adjudicate the case. Previously, when there was no interview for the adjustment of status for the employment based, anybody who has had any arrest record, they were compulsorily interviewed. But nowadays, they do have they do have everybody has to go through the interview process. So you will go through the interview process. You need to be prepared to answer the questions. For the officer is going to ask questions about the DWI when you go to the adjustment of status interview. That's a green card interview.
Niraja from Facebook wants to know if there's anything new going on with the H-4 EAD. So we do have a proposed regulation that was submitted to the OMB for review. That was done in February 2019, and still no action has been taken on it, meaning we still don't have a proposed regulation. So nothing has happened on that front in over a year. We do also have a lawsuit going on that's still in the very early stages, so we're not at a point where any court could make a decision on whether the H-4 EAD was a valid authorization provided through the regulatory process. So at this point, no changes to the H-4 EAD. You can still file it. They're still approving them.
The max out date for L1B is August of 2000 he's applying for L1A, that is transferring from L1B to L1A. Can he continue on the receipt notice, or does he have to wait until the L1A is approved? This is not an extension of L1B. This is actually change of status from L1B to L1A. So you cannot continue working after your work permit expires. That is, your I-94 or H-1B or L-1B that is expiring in August, you cannot continue working until the L-1A is approved.
Rakesh from Facebook, his wife applied for a change of status from H-4 to F-1 back in January, and he wants to know how long does the process take. So it really depends on which service center it's pending at. Some of them are taking only 4 months, some of them are taking 12 to 14 months. But you can actually check that out for yourself by going to uscis.gov. There is a link for you to click there that says current processing times. Once you click on that link, you select the drop down for the type of form, which is the I-539, and then you select the drop down for which service center your application is pending at. That will pull up all the processing times for that type of case at that service center. It will give you a range of the number of months it's taking, and that lately has been relatively accurate. My employer, this is Shrill from Facebook, my employer has sent the package for an H-1B for the CAP fiscal year 2021, and there's no update on the receipt. Has our firm received any H-1B receipt? Actually, today was the first day I received a receipt for any of my CAP cases that were filed last month. USCIS did announce that they really weren't going to be able to start the data entry process until May 1st for the CAP cases, so even those filed in April, we were expecting a delay, but it looks like they are starting to issue them now.
What if the person is going out of status and there's no flights to leave the country? What are the options? You can apply for the B2 visa. You can do it online. You can apply the application. And while the application is pending, you can stay in this country until your flights become available and leave the country. This is available for this B2. A change of status can be applied if you are in a different status. If you are already in this country and you can't leave because of the flights, you can still apply for the extension of the B2 application online. It's a very simple application form. Along with the B2 application, you have to pay the fingerprint fees. Also, you need to submit your current I-94. If you're in H-1B, H-4, try to prove that you are in status. For example, if you're in H-1B, try to present the I-94, H-1B approval, passport copy, and also recent pay stubs. Now, all these things can be done online. Now, I don't have to train you how to do it. You guys know how to do it. But if you have any questions related to that, if you can contact us. But it's a very simple process. You can do that. This question is coming very frequently because of the flights now.
Thiru Kumaran from Facebook wants to know if the 60-day grace period will be extended for a laid-off H-1B worker. I'm getting this question a lot, and unfortunately the answer is no. USCIS and the Department of Labor have made very few relaxation of the rules due to the current situation for those that are here on work visas. So I would not expect the 60-day grace period to be extended. Many other countries around the world have automatically extended status for people that are there on work visas. The United States has not done that, and I would not expect them to do that.
Question from Ramakrishna that the USCIS has temporarily suspended the in-person interviews. Does USCIS processes other things which does not require in-person interviews? Yes, they are processing other cases. They may not be as efficient, as fast as they were before, but yeah, they're processing it. Things are going through. We do get receipt notices, approvals, RFEs, and sometimes denials too. They're continuing to happen. Indraprit has this question: when is the I-140 premium processing is going to resume? At this pandemic time, it looks very tough for us to give any estimate on that.
Rams from Facebook wants to know, for an H-1B, new H-1B who's outside the U.S. and obtains the visa stamp, can you enter the U.S. before October 1st to get things set up like a house and a car? Yes, there is a provision that allows you to enter up to 10 days, no more than 10 days prior to the October 1st start date on the H-1B visa. You cannot work during those 10 days. It's meant for you to be able to come in and get things set up so you'll be ready to start work on October 1st.
Any updates on the H-4 EAD, and what about the biometric suspension for the H-4 extensions? This question comes from Facebook. Unfortunately, biometrics are not open until February 2nd. The H-4 EAD's lawsuit has been suspended right now. At this point of time, we are not filing H-4 EAD lawsuits, delay lawsuits. You may contact us in the month of June. We will come and explain how the things will work out on the existing litigation before we go forward and file any more litigations.
Pavan from Facebook has an H-1B max out date coming up July 13th and is planning to file a change of status to H-4 and wants to know if the H-4 takes effect as soon as it's filed. So the nice thing about the latest version of the I-539 application form for the H-4 is that it allows you to select the start date that you want. So you could file the application now, but request a start date of July 13th. That way your H-4 can be approved in the future when you want it to start, and you're not losing H-1B time. You can keep working on your H-1B until July 13th, and then the H-4 will kick in after that.
Srinivas has this question. He's an L-1B, his employer is laying off. Can he apply for the B-2 visa? And then once the travel restrictions are, can he travel outside the United States? This question is coming very frequently for us. Yes, you can apply for the B-2 visa. It's the only thing that is available for you is to apply for the B-2 visa to stay legally in this country. And when the occasion comes in, especially with the flights, then you can leave the country.
Amal from Facebook wants to know if there's any benefit from the Healthcare Resilience Act if you have a previously approved I-140 with the old employer, but you have not started a perm or I-140 with the new employer. So at least the current version of the bill does not provide any changes to the normal process of making sure that you have an approved I-140 or approved labor certification I-140 with the employer that's actually sponsoring you. So I think that you would not be able to file the 485 if the old job offer is no longer there.
Question whether the 60-day grace period will be extended. We are not anticipating any extension of the 60-day grace period. In fact, the Trump administration want to restrict more rather than actually liberalize more.
Arun from Facebook has an H-1B filed for consular processing and wants to know if he can travel to a closer consulate like Mexico to get the visa stamped, or only the one that's mentioned in the I-797 approval notice. So back in the old days, you were stuck going to the consulate that was listed on your approval notice and had to actually file an application to notify a different consulate. That was a long time ago. Now they have this PIMS system where all of the information about the petition and the approval are available to all the consular officers all over the world. So if you can get an appointment at another consulate, you're able to go there. The only restriction on that is if you originally entered on a B1 or B2 and then you're trying to apply for the visa in Canada or Mexico, they don't allow that.
Will the dentist be included in the medical bill? This question comes from Prithviraj. We are not anticipating the dentists to be included in this bill. Another question, interesting question that comes from Venkat is that his aunt is on B2, her identity expiring. They're applying the I-539 extension. Can she travel while the extension is pending when it's not approved? Will it create any problem if she travels while the extension is pending? No, it will not create any problem if you travel while the extension is pending. But make sure you keep the documentation you did file for the extension. When somebody asks, when you're trying to enter into the country, how did you stay beyond May 20th? That's when the I-94 is expiring. You can tell that, look, I did file the B2 extension that was pending at the time. You show all the evidence. That will be good enough for you.
Krish from Facebook lost the job with employer A, unfortunately, and that approval notice is valid till April 2021. He wants to know how much time he has to transfer to employer B if employer A withdraws the H1, and whether he needs to maintain health insurance active during that time. So from the time of the job loss, not the time of the withdrawal, that's when you start counting the 60-day grace period. So from the day you stop working for employer A, you need to file the transfer to employer B within 60 days. As far as maintaining health insurance, there's no requirement, no immigration requirement if you're staying in the U.S. to keep that health insurance active in between. There may be tax consequences of not having health insurance for a part of a year, but nothing from the immigration side if you're in the U.S. and filing a transfer.
Question comes from Chaitanya. The person is on H4 EAD. They lost the job. Are they eligible for the unemployment benefits? Will it cause any problem for the extensions or the GC? H4 EAD people are eligible for the unemployment benefits. It should not cause any problem for the H1 extension, H4 extension, or also for the green card processing. According to the USCIS, the unemployment benefits are not considered to be public charge things. Now, having said that, please make sure that this is only for H4 EADs and L2 EADs. H1Bs and L1s cannot apply for unemployment benefits. The reason is that it is a restricted employment as compared to the H4 or L2 EAD, where there is no restriction for them to work anywhere. So that's the reason why only H4 EADs and L2 EADs are eligible for.
Grishma from Facebook wants to know, after applying for the H4 EAD, can I travel to India when the application is in progress? So assuming you're talking about just the EAD portion, if you file the I-765 while you're in the U.S. and then travel, no issues at all, that you can do that without any problems.
Ashok has this question, do you expect any 2021, the quota cases, do you expect any delays? Yes, Ashok, I'm expecting delays in the H1B processing in the 2021. One simple reason is that there is no premium processing available. So that's a reason why, one of the reasons why it will be delayed. Jagrut has this question, what about the pharmacist? They play a crucial role, and what about in the bill? Yes, pharmacists do play a crucial role, especially under the current circumstances. You may want to lobby the government, send letters to them. Look, we are pharmacists too. We are the front-end healthcare workers too. So you should, at this point of time in the bill, they did not include, so you may want to have your pharmacy association or pharmacy unions to contact the Congress and represent yourself. It's definitely worth for you to work on that too. Why not pharmacists? What wrong have they done? Nothing. I mean, you guys are there too. You should be getting the benefit too, but please contact the Congress to get included in the bill.
Pavan from Facebook is planning to apply for a change of status from H1 to H4 and wants to know if his spouse later changes employer, does he need to apply for the H4 again? You don't have to in that situation, but you may want to. So the H4 that's pending is not tied to a particular employer, it's tied to your H1 and your maintenance of H1 status. So as long as you're maintaining status with any H1 employer, the H4 can still be processed and approved. Why would you want to file the H-4 again when you're filing a transfer? Mainly so that you can both have the same end date. So when the transfer is being filed, you're likely going to be requesting a 3-year extension from the time of transfer filing. So the H-4 can be, extension can be filed at the same time to get that same end date. Otherwise, the H-4 is going to end earlier when the previous H-1 extension expires.
Question from Anshul is that, is there any update on the H-1B petition which status shows submitted? After the initial selection of the lottery, which happened in March 31st, somewhere about April 3rd, April 4th is what we have seen the changing, whether it's been submitted and then whether it's been selected in the lottery. We haven't seen any changes whatsoever at all in the entire second half of the April or in the May month. We have not seen any changes at this for the submitted applications. It's very hard at this point of time to tell that any changes could occur. They've already selected more people than what the numbers are, which is 65,000 plus 20,000. So if there is anything, we may expect something only after June 30th, none before that. That's my guess. And please don't hope that you'll be selected in the lottery if you is just submitted. I want you to plan your life without getting selected in the lottery and then go about, and if something pops up, it may, but don't live in the daydream that yours will be selected.
Viren from Facebook wants to know if an LCA amendment is needed if we're working from home rather than the office location, which is different. So if the home location where you're now working is within the same metropolitan area where your LCA is currently valid for, no amendment is needed, no new LCA, nothing has to be filed with USCIS. If your work location at home is in a different metropolitan area, let's say that you actually live in New York, but you were commuting to Houston and now you're going to work from home from New York, that location is not part of the LCA that you have that's valid. So a new LCA, an amendment is normally required unless your employer meets the requirements for the short-term placement provision that allows you to work for 30 or up to 60 days in 1 year at a location that's not on the LCA as long as they meet certain requirements.
Question from Das Gupta is, when do you expect the consulates to reopen? They're expecting consulate to reopen in the later part of May. What do you say, Emily?
I've had a couple people that were able to schedule interviews in July for Mexico. So I would assume Canada is going to be similar.
I was been told that some people were able to schedule in June, but I haven't seen the confirmations yet. The government at this point of time want to reopen as soon as possible, so they don't want to keep hanging around for the next 6 months for sure. So we're anticipating things to open at the later part of the May. Emily might be anticipating in June, July, but I'm anticipating the later part of the May.
Chaitanya from Facebook wants to know, how long does the H-4 approval take filing with USCIS, especially with biometrics not happening right now? So, before we had the biometrics issue, they were taking anywhere from 4 months to 8 to 10 to 12 months. It really depends on the service center, and you can check those processing times on uscis.gov. Now that biometrics are halted, you can only imagine the number of people that are lined up waiting to get their biometrics appointment once these local offices reopen, hopefully after June 4th. So I think there is going to be some initial backlog of getting all of those people that have not been able to attend their biometrics, plus new people that are filing. I would expect processing times are going to get worse before they get better.
Priya has this question: how long can she stay on H-1B out of the country while working outside the country for a U.S. company? You can stay for a long period of time. I mean, there's no restriction. You can stay up to 6 months, 7 months, 9 months, 1 year up to depends on the circumstances. When you're entering back into the country, Priya, here is what they are looking at. you are not in the country for so long. Do you still have the job with the same company which filed the H-1B? Since you're working with the company in India while you're outside the country though, that's an easy thing to prove. So I don't see much problem for you to work for a long period of time, especially under the current circumstances. We have had situations where people were, stayed for a long period outside the country and then they came in. The main question was that do they still have the job? So since you're already working, that becomes more easier to prove, especially at the time of entry.
Sandeep has a good question. He wants to know if USCIS processes H-1B extensions differently for essential organizations like pharmaceutical companies, which are in the field of supplying medicines for COVID-19, and do they allow premium processing in such exceptions? No. I've not seen any changes in how they are processing H-1B extension applications based on what type of work the company does or what type of work the employee does. They don't have any exceptions for premium processing. Your employer could try an expedite request, but even with that, you have to fit one of the 4 categories, and there isn't a new category for COVID-19. But it doesn't hurt anything for an employer to try an expedite.
If you may use that, if you work with the COVID situation though, if you request the expedited thing and then list COVID out there, you may have a sympathetic view on getting the expedited request though. But no premium processing is available. It's just the expedited request. Paul has this question, does H4 extension require biometrics? Unfortunately, the answer is yes. It requires biometrics. Sudhakar has this question, how long it's taking to change the status from F2 to F1? It may take anywhere between 8 months to about 18 months to get the F1 approved.
Naveen from Facebook wants to know if a physician working on an H4 EAD could qualify under this new physician bill. Yes, there's nothing wrong with that. The basic rules for any adjustment of status is that you have to be maintaining your current non-immigrant status at the time of filing, whether that's an H-1B or an H-4 EAD, either of those are fine. Then you have to have an approved I-140 and a current priority date. Those requirements are all the same, so I don't see any difference that would be created simply because you're on the H-4 EAD versus another work visa.
Question from Prasad, can the H4 and H4 EAD extension be applied at the same time? Yes. It's strongly recommended that you apply for the H4 and H4 EAD at the same time. Otherwise, both applications will get separated. It's not what I would strongly recommend that you apply both the things at the same time. Question is that if the from Deep, a person who wants to change from H1 to H4, do they still need to do the biometrics? Yes. Anytime you're extending the H4 status, you are changing to H4 status, you have to have the biometrics done.
Vikram from Facebook wants to know if a client manager can force you to work additional hours but only pay you for 40 hours of work, and if possible to file a complaint. I think it depends on, I'm assuming you're in H-1B status, what are the terms and conditions that were listed on your H-1B petition? If it's a salaried position, you're paid the same amount regardless of whether you work 8 hours a week or 60 hours a week. That's what salaried positions are. There's no overtime pay, even if they're forcing you to work more than the usual 40 hours a week. If it's an hourly position that comes under the overtime rules and they're not paying you the overtime, that's where you have a problem and you would need to file a complaint with the Department of Labor.
Jaya has this question, does a nurse and doctor have to work on COVID patients only to get the green card under this new bill, or can they just be nurses and doctors? My reading of the bill says that you just have to be nurses and doctors because they need people at this point of time. So if you're not working on the COVID, if you're a nurse, you're not working, but you're relieving another nurse to work on the COVID patient. So that still should be. I'll be very surprised. With 1 million+ people in United States getting contact with the COVID, And it is expected that million plus is expected to reach about 5 million. I don't know. I'll be very surprised if a nurse or a doctor will not come across a COVID patient.
Sundeep from Facebook wants to know what's the current time for LCA approval where you need to file an amendment because you're working at a new location. LCAs are still processing normal processing times, right around 7 days. We have not seen any delays in that.
Rajiv, does healthcare people who are nurses and doctors, can they benefit if they have not applied for the green card? Yes, I mean, assuming the bill as it is passed today, it will benefit. You can apply for the green card right now, and you don't have to have applied before. As long as you apply right now, I don't see any problem in you benefiting through this one.
Ritesh wants to know which healthcare workers are included in this act, and are they going to include all Schedule A workers? So at this point, only nurses are the ones that fit under both Schedule A and this new bill. Physical therapists are included under Schedule A, but not included in this new bill. Doctors are not part of Schedule A, but are included in this new bill. So they're really completely separate things. So Schedule A is what allows nurses to skip the labor certification process. This bill would allow nurses and doctors to have more green cards available so that you can actually file the adjustment of status if you have an approved I-140.
I need your attention on the Srinath's question, Emily, is what are the chances of this bill to pass through since no immigration bills have been going through to the Congress? And the interesting question is, why only 40,000? There are 200,000 available for recycle. Why only 40,000?
Great questions. Out of any bill that's been proposed in the last 20 years, this one seems to have the best chance of approval because I think there is a lot of support for the idea that we clearly have a shortage of nurses and doctors, and that a large percentage of nurses and doctors are foreign born. So I think that this pandemic has really called attention to the fact that there is a shortage, and that's why we have a good opportunity to pass it, even if the current administration is generally anti-immigrant. As far as why only 40,000, why not 250,000? Same reason. I think with the current political aspects, there's plenty of conservatives that are anti-immigration and are not going to allow 250,000 more people coming in to get their green cards. That's why they claim they need the current immigration ban to block legal immigration. So, I think they're trying to set a reasonable amount. These are the numbers of doctors and nurses that if we were able to get them here with a green card, that they could help ease the shortage.
Yeah, I think so that, in the past, 20 plus years, or I've been practicing, this bill has a best chance and so easy to pass. I don't think so, and with the pandemic situation right now, I mean, the congressmen will have very little to show why they oppose this bill if they do. I'll be very shocked if any of the congressmen will oppose this bill, though. So, especially in the Senate, which is where most of the hurdles are in passing the bill, I don't think so. They will have any hurdle in the Senate. The Congress, they just need a simple. The House, they just need a simple majority. I think so. That should fly through very simply. And also to note that recently there was a bill for PPP loans that passed through because of the COVID situation so fast. We also seen some reimbursement for the taxes that people have paid. That passed through. So a lot of things that are related to COVID, where the president needs some action. The Democrats and Republicans have come together only for the COVID situation. They have come together. They've been fighting. We have seen the State of the Union address where, Trump's statements were being just torn down by the speaker, though. Now, when you look into right now, the situation is they are working together in getting the things under control, especially with the COVID. People do expect them to work, and this is related to the pandemic situation we are, and this bill is expected to help the pandemic situation that we are in. Our lives and our health is in danger, and I think so that this bill is expected to go through smoothly. That's the reason why I think so this bill is expected to go through.
Praveen from Facebook wants to know if USCIS is accepting applications for H-1B and H-4 extensions now, and whether his wife can continue to work while her H-4 and EAD extensions are in process. So yes, USCIS continues to process H-1 extensions, transfers, L-1s, L-2s, H-4s, TNs. Anything you can file with USCIS, they're continuing to process, even with this most recent executive order from President Trump. Now, as far as continued ability to work on an H-4 EAD, if the H-4 EAD expires before the new one is issued, the H-4 cannot continue working, even though the extension is pending.
The questions came in. What about the 386 bill? Well, it's on sideline right now. That's not going to be there. Next question that came on the bill is that can it be challenged in the court? This is a Congress that is expected to pass this bill. This is not regulations. This is not an executive order issued by the president. Yeah, it could be challenged in the court, but the chances are very light that court will do anything about this bill if this bill is passed. I'll be very, very, very surprised if the bill is passed and it gets stuck in the court. I'll be very surprised because once the Congress has passed the bill, the only thing that is going to stop it is if it's unconstitutional. So I don't think so this is an unconstitutional bill at all. Sujit has this question, will this bill help EB2 Indian nationals? Not to a great extent, Sujit. One reason is that this bill only it knocks down some of the people out of the line. So there are 800,000 people that are in line right now. It definitely knocks out 40,000 people out of the line. That definitely. Then the question is that were all those 40,000 before you or they are behind you? How much of those people are before you? So yes, it may give you some relief, but I'm not expecting big jumps in the EB2 backlog for Indian nationals.
Bharat from Facebook is currently working on H-4 EAD and has an H-1B that was picked in the lottery this year and wants to know if he can continue apply for the H-1B with consular processing and continue working on the H-4 EAD. Yes, you can absolutely do that. The only thing I would caution people on that is when you get an H-1B approved for consular processing, you're technically not considered counted in the cap yet until you actually get that visa stamped. So if you're working on your H-4 and your H-4 EAD and you consular process the H-1B and then you lose that job and go to a new employer, that new employer cannot take advantage of that H-1B and you have to go through the lottery again. So it may be better for you to change status to H-1B, have it take effect on October 1st, then you could always go back to H-4 and EAD if you wanted to, and then you've at least got your H-1B in place, counted in the cap.
Sai Krishna has this question. My perm labor is approved with employer A. I moved to employer B. Can I apply I-140 with employer A without moving back to company A? Technically, you can apply for the I-140 with company A. This is for the future employment. So if the company A wants to employ you in future, even though you're not working, or even though you left the company right now, yes, they can apply for the I-140.
Siddhartha from Facebook wants to know, can I use my B1 visa after the 240 days period? The B1 was filed by a previous employer and is still valid. So what you have to understand is the B1 visa in your passport allows you to enter in B1. It does not provide you B1 status. To get B1 status, you either have to travel and come back in or file a change of status with USCIS to B1. For that to happen, you have to have a legal business-related purpose of applying for the change of status to B1. So generally, no, you can't use that visa from the previous employer in order to stay. You have to either travel and enter on B1 or file a change of status to B1 if you qualify for it.
RA has this question. He's maxing out in August of 2020. He's speaking about a 6-year max out. will I be cap exempt if my employer files a perm application and gets an I-140 approved? Yes, if you have a perm and I-140 approved, you could get the exemption from the cap exemption. You could do that.
Sudhakar from Facebook wants to know how long it takes to change status from F2 to F1. Depends on which service center it ends up. It could be anywhere from 4 months to 12 months, even longer than that. Paul from Facebook wants to know, does the H4 extension require biometrics? Yes, it does. If you're filing with USCIS, you file the H4 extension on the I-539 application, and biometrics are required every single time, regardless of how many biometrics you've given in the past. Even for babies filing the H4 extension, it is required.
Emily, I need your attention on this one. How much percentage of salary increase that you will consider for H-1B amendment? Let's say, for example, a person is making $80,000. If he gets a normal salary increase of $2,000 to $3,000, we don't file amendment. But is there a limit? What is it? Is it like 10%, 5%, 20%, 30%? What is your judge?
Yeah, I think that's difficult because there is no number. There's no bright line test. What I look at is how much have the job duties changed, and I look at what prevailing wage level was used on this person LCA before, and is this wage taking the person up above the next level? That would suggest maybe it's a higher level job, and that's why the salary has changed. That, I think, might require amendment. If you're going within the prevailing wage level that you're already at and the job duties are staying the same, it's just a raise, I don't see any issue with that. That's kind of what I look at.
Is premium processing available for the non-profit higher education institutions? This question comes from Rani. The answer is no. Premium processing is not available for non-profit entities at this point of time. How many times can a person use the 60-day grace period? For each H-1B, you can use one 60-day grace period. Absolutely. For each H-1B that you get it approved, you can use 60 days. So you move from company A to company B, you can use the grace period. Once company B's H-1B is approved, you want to move to company C, yes, you can use the 60-day grace period. It's per each company.
Sona from Facebook has an H-1B transfer approved, so she has an approval with company A, the current employer, a transfer approved with company B, and company A wants her to continue working for 2 more weeks to complete the project after she's already transferred to company B. Will that be an issue? Yes, it is an issue. You can only work for one employer at a time, so since you've joined company B, you have to stop working for company A. The only way to work for 2 employers at the same time is by filing a concurrent H-1B petition. So if that was not filed, it cannot be done.
Manmeet Singh is asking the question, is a pharmacy research scientist included in the bill? And Nandan is asking whether dentists are included in this new bill. Unfortunately, both of them are not included in the new bill.
Sai Kishore has a perm approved with an employer A and then moved to employer B and wants to know if he can apply for the I-140 with employer A. It really depends on whether the permanent position that employer A has sponsored you for, if they continue to intend to offer it for you and you continue to intend to work for that company when you get your green card. So if you are temporarily working for company B and have plans to go back to company A could file that I-140 for you. Not being on company A's payroll could create issues for the I-140 because the company has to prove that they have the ability to pay your salary. So if their tax returns do not show enough income, then your I-140 could actually be denied if you're not working for them.
Akshay has this question. Can you explain more about the concurrent H-1B filing? This is, we were very surprised that a lot of people are not aware of this concurrent filing. What that is, Akshay, is that you can work for 2 different companies at the same time. So if you're working with company A and you want to also work with company B, you can file a concurrent filing. Are there any potential issues? No, no potential issues. You keep making more money, you pay more taxes. That's good for you, good for us, good for the entire economy. Absolutely no problem with it. Not many issues. I mean, the regular issues that come with the H-1B, that's it. And to concurrently work on a H-1B, you don't have to get the H-1B approval. Once you file the concurrent H-1B, you can start working with the second company. Especially a lot of people are staying at home. They have a lot of time left out. You don't have to go, wake up and, you travel 1.5 hours, take a train and go. You have a lot of time left. And if you want to work for 2 companies, you can do it. You can work for 3 companies if you want to. If somebody wants to work for 2 full-time companies, they can do so. And I know some people who work 80 hours a week. You can do so. But if you want to do 1 company full-time, the second company part-time, you can do so. Do you need to inform the first company that you're doing a job with the company B? As far as the immigration is concerned, there is no rule that you have to say to the company A that you're working for company B. However, the second company, when they are filing, they need to know that you're working with company A, because in their application, they have to mention that you're going to be concurrently working for them. That is required to inform the second company. The first company, as far as immigration is concerned, you are not under any obligation to inform the company A. Will the company A come to know? As far as the immigration is concerned, when they file, no, they won't come to know.
All right, I think we're about out of time for today. Thanks so much for joining us. If we didn't get to your question, or if you would like more detailed information, I do want to remind you that we have a daily conference call that you can join in. It's free. If you go to rnlawgroup.com, you can find the phone dial-in information there for that. You can ask your immigration questions just like we answer here. If you want more detail on your specific situation, you can set up a consultation with us or any of our attorneys here at Reddy Neumann.
And then we do have a 50% discount on the consultation if you book a consultation before April 15th across the board for all, because of the COVID situation.
May 15th.
Huh? May 15th, sorry.
Still in April. It doesn't feel like it's May yet.
Yeah.
So please, you can go to rnlawgroup.com. You can schedule your appointment online, see all of our attorneys and their areas of expertise, and pick the one that works best for your schedule. So thanks for joining. We'll see you next week.
Thank you, guys.